regard being had to the fact that we are dealing with a judgment dated 12th May, passed by the learned single judge in writ petition such and such, cancelling the appointment of 32,000 candidates who were untrained at the time of selection in the recruitment process conducted by the board. It was also inter alia directed that the board to immediately arrange for a recruitment exercise for the candidates who were untrained within a period of 3 months. Assailing the said order, it went up to the intra-court appeal, wherein an interim order was passed against which Supreme Court was approached. Supreme Court relegated the matter for fresh consideration of all the issues upon allowing the addition of party. The matter involves cancellation of appointment of 32,000 primary teachers who have rendered uninterrupted service till the date in different primary schools all over the state. It has been alleged inter alia that the board committed fraud and the recruitment process was not conducted as per the West Bengal primary teachers recruitment rules of 2016. Whether such circumstances would warrant a zero tolerance approach or as to whether it would be iniquitous to interfere with such appointments had compelled us to pause, ponder, and confer anxious consideration upon the same, which would require untangling of a complicated mesh of competing rights. So we went on to record the submissions as have been advanced by the learned counsels appearing for the appellants. Mr. Dotto was there, Mr. Anindo Mitro, Mr. Joyanto Mitro, Mr. Kollan Mondobadhyay, then Mr. Obrotosh Mojumdar, and the other councils. Pardon us if we have missed some dates, it is there. We have also recorded the contention of Mr. Ashok Banerjee, Mr. Saptang Subashu, Mr. Pratik Dhar, Mr. Parthasarathi Bhattacharya, Mr. Obrotosh Mojumdar, and other learned counsels we have appeared. It was opposed by the Mr. Kumar Torunjyoti Tiwari and Mr. Torunjyoti Tiwari, Mr. Bikash Ranjan Bhattacharya, Mr. Firdos Shamim, Mr. Sabir Ahmed, Mr. Other advocates were there. We have recorded their submissions and we have considered the same. So we have proceeded to deal with the matter, deal with the judgment which has been impugned in the present appeal. The findings of the learned single judge can be culled out from the impugned judgment are as follows. No aptitude test was held. There was no formal engagement letter for acting as an interviewer, nor any guideline for awarding marks for aptitude test. The marks given to the candidates against aptitude test is wholly illegal and false exercise to hoodwink all concerned, including the court. There was a wholly absurd assessment in interview, and such assessment reveals extraneous factors, which includes corruption, as has been alleged by the petitioners and now has come to light from the investigation by CBI and ED. Non-empanelment of reserved category candidates in the panel for general category candidates who got better marks. No selection committee was constituted for the purpose of selection by the board. An outside agency was engaged and the board and its officials, including the former president, conducted the whole affair as that of a club, and jobs were actually sold to candidates who had the money to purchase the employment, and that lastly the recruitment scam, stinking rats are being smelt. We dealt with each and every finding of the learned single judge, and we went on to observe as follows. Upon dealing with the judgments on which reliance was placed before us, including the judgment delivered by a coordinate bench in the case of Boishaki Bhattacharya. So we ultimately concluded to this effect. It is true that courts should emphasize the need for fairness, transparency, accountability in public service, and shall support wholesale cancellation of examination if systemic irregularities undermine the process integrity. Systemic irregularities refer to widespread flaws, malpractices within a system, process, or organization. It includes cheating and impersonation, large-scale irregularities, including those which have the effect of denying the equal access to similarly circumstanced candidates, are suggestive of malice, eroding credibility of process. However, court is not expected to indulge in roving inquiry to rule out all possible explanations and alternative scenarios justifying such irregularities. There is a difference between a proven case of mass cheating in a board examination and unproven imputed charge of corruption. When services are terminated on the ground that the incumbent aided and abetted corruption, the court must satisfy itself that condition for this exists. The irregularities alleged in the writ petition were primarily pertaining to TET 2014, through which the candidates earned the eligibility to participate in the interview and aptitude test. While deciding the issue urged, the court went beyond the pleadings and cancelled the appointments made upon a purported finding that no aptitude test was held. In the dispensation of justice, courts are prevented from innovating at pleasure. Neither can they don the helmet of a knight errant roaming at will in pursuit of his own ideal of beauty or of goodness. At all times, courts are expected to draw inspiration from consecrated principles. A finding as regards widespread or systematic irregularities is absolutely indispensable for cancelling all the appointments made. For cancellation of the entire examination, there must be as a rule possibility of systemic malice as borne out by materials on record. Assessment of the data does not indicate systemic cheating. It also does needs to be mentioned that during the period of service rendered by the appellants, there had been no allegation regarding the integrity or efficiency of those teachers. It is not a case that instructions were given to the examiners to give higher marks, or that the candidates who paid money had been given higher marks in the interview. A group of unsuccessful candidates should not be allowed to damage the entire system, and more so when it cannot be ruled out that innocent teachers would also suffer great ignominy and stigma. The service of the appointees cannot also be terminated only on the basis of an ongoing criminal proceeding. Reliance has been placed upon the charge sheet and supplementary charge sheets by the writ petitioners. In the same, the investigating agency observed categorically that appointment letters were issued upon receiving recommendation letters from the board. Findings arrived at by investigating authority would not reveal that the appointed candidates were involved in any corrupt practices. Upon investigation, it was ascertained by CBI that irregularities exist in respect of 264 candidates who were given grace marks and were identified. Additionally, 96 candidates also did secure qualifying marks were appointed and they were also identified. Subsequently, these 96 candidates were terminated, but they are still continuing service on the strength of order passed by the Honorable Supreme Court. In view of such identification, the allegation of fraud and corruption pertaining to the entire recruitment process is not sustainable. It is the impact of the action that would define the nature of the procedure that is to be adopted. The effect of any direction for re-examination at this stage would have a dissimilar impact upon the appointees. Any such direction for re-examination would fail to secure fair play in action. A job taken away after about 9 years of service would indisputably cause insurmountable inconvenience to the appellants, and their survival along with their family members would be at stake. In such circumstances, and considering the enormity of the impact, we are not inclined to uphold the cancellation of appointment of 32,000 teachers who have worked in the post for a long period.